Good morning, everyone. I'm Keith Bradley. I'm a partner here at Squire Patton Boggs, and welcome to our webinar about the 2024 revolution in administrative law. Before we all introduce ourselves, I do have a couple of housekeeping things to mention. First is that this program is pending for CLE credit for 1 credit general hour in Arizona, Colorado, California, New York, and New Jersey. It is also approved in Virginia, so you'll see the appropriate code that you need to claim credit at the end of the program. We are recording today's program. During the presentation, you'll be all remaining on listen mode, and then we will circulate the presentation materials as well as the recording in the days after the session. If you do have any technical difficulties, please send a message to the team asking for assistance, and the way to do that is with the Q&A panel. If you look at the lower right of the window, you'll see a little square box with a question mark in it that says Q&A. If you click on it, that's the way you can, if you select host option, you can send a question to the IT team. And then you can also use that same box to select all panelists to ask a question to us, and then we will reserve some time at the end of the presentation to answer your questions. If we don't get to your question, just given the time, we will follow up with you shortly afterwards. Brief bit of introductions. I'm Keith Bradley, as I said. I'm co-chair of the firm's appellate and Supreme Court practice, and what I do primarily is litigate against the federal government. I teach administrative law. This is what I live and breathe, so it has been a very exciting couple of weeks for me. Patty?
Thanks, Keith. Hi, my name is Patty Dorsch. I'm a partner in the firm's public policy practice here in Washington, D.C. My work involves primarily regulatory compliance matters in the transportation and infrastructure sectors. I spend a lot of time helping automotive clients regulated by the Department of Transportation meet their obligations and challenge the government sometimes when they get it wrong.
Ben?
Yeah, hey, I am Ben Glassman. I am a partner here at Squire Patton Boggs in the Cincinnati office, where I'm actually the managing partner of this office. My principal work is in government investigations in white collar. I'm the deputy chair of our practice group for government investigations in white collar. And so the principal work that I do is helping diverse clients who are or potentially could be under scrutiny by a principally federal enforcement agency, whether that's the DOJ, CFPB, SEC, to name a few. And then in addition to that, I have a substantial appellate practice here in the United States Court of Appeals for the Sixth Circuit. Oh, I should mention, before all of that time, before rejoining private practice, I was the United States Attorney for the Southern District of Ohio, and before then a federal prosecutor. So that's where my enforcement background comes from.
Excellent, thank you. So the title of this webinar is the 2024 Revolution, Chevron and Beyond. We think of it as actually a quartet of cases. There's even more than that. But we're going to talk about all of the 4 big ones. And let me offer you 2 big takeaways. One is you have all probably heard about Chevron and the overruling of Chevron, and the news is full of that as though it is the earth-shattering event. It is important, but it may not even be the most important of these 4. So there are bigger changes afoot, of which this is but one piece. The second big takeaway is they are all very important, but they are none of them none of them is wiping the chess pieces off the table. What these mean in your life as a regulated entity, or your life as somebody who deals with regulated entities, or you're dealing with the government, is nuanced. And one of the big impacts is that there were some things that were true across the administrative state and are no longer uniform. More things now are agency by agency, statute by statute, case by case. There are opportunities and risks coming from these big decisions, and it's going to take, for better or for worse, careful thought about each situation to figure out how best to navigate those. So first, we'll just talk about briefly about what actually got decided, like the specifics of each of these cases, and then we'll talk about the implications. First one that you've already heard about, I'm sure, is Loper Bright versus Raimondo. This case arises from the Department of Commerce, which has a rule that says fishing vessels have to not only carry observers from the federal government, but they actually have to pay for the observers. And the fishing vessels say the observers are not from the federal government. They are third parties that are acting on behalf of the government, paid for by the fishing vessels. And some fishing vessels complained and said we should not have to pay for them. They're doing government work. Government should have to pay for them. Ultimately, this is a question of what the statute does or does not allow, and the statute doesn't actually say. This became a Chevron question because the DC Circuit held that since the statute does not say, it was going to defer to the agency's interpretation under what is called the Chevron doctrine. And this case came to the Supreme Court as the question, should we overrule the Chevron doctrine of deferring to agencies on their statutory interpretations? And the court says yes. What actually happens to the fishing vessels and the paying for observers, we don't know. The court sent it back down for the agency to redo the statutory interpretation fresh without giving Chevron deference to the agency. This is really the key paragraph, and we'll talk a little bit more about this. It is important with Loper Bright to understand exactly what it did and did not say about agency deference. It specifically overruled Chevron, meaning a concept of agency deference that has built up over the years, and this is the sort of money paragraph telling you exactly what they think Chevron is that has been overruled. Second case that we want to talk about is SEC versus Jarkesy. Ben?
Yeah, so at the risk of throwing off the entire rest of the webinar, I want to start with the one thing that I am confident you will all take away from this, which is that the correct pronunciation of this party's name is Jarkesy. So this actually was discussed during the case after an hour of the government attorney talking during oral argument, with the justices calling this person all kinds of different pronunciations. At 1 hour and 13 minutes into the oral argument, Jarkesy's lawyer explains that actually this guy's name is pronounced Jarkesy. So now you have that tidbit to take with you for all cocktail parties over the next couple of weeks. What happened in Jarkesy? Well, the SEC's enforcement division believed that Jarkesy and his company misled investors and got more management fees than they should have been getting. And the SEC's enforcement division said this is in violation of the anti-fraud provisions of the securities laws. And so we're going to seek civil monetary penalties against you, Jarkesy. Jarkesy said, hey, I think that I have a right to a jury to hear that accusation. And the SEC said, no, you don't, because under Dodd-Frank, we can choose whether we want to proceed in federal court or whether we want to proceed before an ALJ in-house within our own adjudicatory system. And so the SEC proceeded through, and the ALJ said, in fact, yes, Jarkesy is liable, and lo and behold, the commission as a whole affirmed that decision. Jarkesy proceeded to then pursue his argument about the Seventh Amendment in the federal courts all the way up to the Supreme Court, at which point the Supreme Court said in a 6-3 opinion that Jarkesy is right. The pursuit of civil monetary penalties by the SEC is akin to common law fraud, and that is protected by the Seventh Amendment right to a jury trial. So Jarkesy had a right to have the SEC's enforcement action proceed against him in federal court with a jury if he so chose.
The next one we need to talk about actually came out on the very last day of the term. This is Corner Post versus the Fed. Corner Post is a merchant. It's a convenience store and truck stop in North Dakota. And they are upset about the fees that they pay for debit cards. As many of you may know, merchants, when they accept a debit card or a credit card, they pay what's called an interchange fee and a couple of other fees that they pay to their bank. That then gets processed through the card networks. For debit cards, that fee has been capped for over a decade under a provision from the Dodd-Frank Act that told the Fed that it was supposed to set a cap. That's been capped at 21 cents per transaction under what's called the Durbin Amendment rule. That rule was adopted in 2011. It was litigated. The DC Circuit ended up saying that it was okay, and that has been the state of affairs for 10 years now. Corner Post opens its doors in 2018 and says, we weren't around back then. We didn't get to participate in that fight, and we are now having to pay these fees that we think are too high because the Fed got the rule wrong. The cap should be lower than what the Fed said. And the fight is whether the statute of limitations has elapsed. The background statute of limitations is 6 years, which was generally thought to start at the time of the rule. And what the Supreme Court said is, no, that statute of limitations starts running once there's an agency action and you are injured by it. So for Corner Post, they didn't exist till 2018. They paid their first interchange fee in 2018. That is when they were first injured. And so they are allowed to bring a facial challenge to the rule. We'll talk a little bit more as we get into it, what that difference means, what that means to be bringing a facial challenge. But the bottom line is this debit card fee cap that has been settled since 2014 is now up for full dress litigation again in a different court.
Okay, Ohio versus EPA. Happy to jump in and explain this one. This case involved a multi-state challenge to EPA's air quality standards for ozone. EPA adopted new standards in 2015, and those standards required each state to adopt its own plan to implement the rule. So the EPA eventually found deficiencies in 23 of those states' plans to address ozone pollution and disapproved of them, and then developed its own federal plan to govern those 23 states. Some of those 23 states challenged EPA's disapprovals. Lower courts stayed 12 of those, meaning that the EPA could not enforce its federal plan for in 12 of those states. Then some of the remaining states who did not get lower court stays, but they still had deficient plans, challenged EPA's federal implementation plan, saying EPA's decision to apply their federal plan to their states after so many other states were no longer subject to it was arbitrary, capricious under the Administrative Procedure Act. So the states asked for a stay of that federal plan while they challenged it. DC Circuit denied the stay. The states renewed their challenge at the Supreme Court. The court heard oral arguments and granted the stay, finding basically that the states were likely to succeed on the merits of their claim that EPA's actions were arbitrary and capricious because EPA failed to reasonably explain how the agency's own federal plan, designed to cover 23 states, was now still appropriate just to apply to the remaining 11 or 12. The broader takeaway in this case, though, actually involves the state's request for a stay. In deciding whether to grant it, the Supreme Court applied the same four standards that have always been considered, which is whether the applicant's likely to succeed on the merits, whether they will suffer irreparable harm without a stay, whether the stay will substantially injure other parties interested in the proceedings, and where is the public interest here. The court quickly disposed of the final three factors in the test in a single paragraph, basically finding that both sides faced weighty harms, and therefore the way to decide the emergency stay was basically on the merits of the claim. The court's application of the stay factors here, they relied on for the final three factors, was heavy compliance costs and the competitive disadvantage faced by the states who would be subject to the federal plan when some states were not. That was enough to put the three stay factors in balance and made a question down to likelihood of success on the merits. I just want to briefly mention that what the dissent said here. They addressed the majority of the majority's arguments on the APA claims rather than the other three stay factors. But they did provide some valuable cautions, I think, in the dissent, reflecting the tension that's often present in requests for emergency stay, when they basically criticized the majority for what they call they decided a fact-intensive and highly technical case without fully engaging with both the relevant law and the voluminous record. So I think that's a caution that's relevant in all of these instances.
I agree that it is, and I think it makes a big difference. Thank you. So we've got a big picture slide. I'm not going to walk through these bullets. Instead, I want to talk about how this plays out, or how all of stuff could play out if you imagine a real situation arising. So an agency has just issued a decision. Maybe it's maybe it's a new rule. Lots of things there are very substantial policies that they implement, not by rules. And your client is upset about it in some way. How does all of this make a difference? First thing to think about is actually going to be that I want to think about is Ohio versus EPA for a couple of reasons. I should disclose that we represented one of the private sector parties in that case. The court took this case on purpose. It was very unusual. You may have heard about the court's shadow docket in recent years, in which they engage in a lot of substantive work that is not the classic take a case, get the briefs, do oral argument. They do a lot of work through like temporary relief and stays and things like that. This was a highly unusual situation in which they had an application for a stay of a case that was pending in the DC Circuit. There's been no merits decision from the DC Circuit yet in this case. There was the DC Circuit denied a stay, and then the parties asked the Supreme Court to order a stay while the DC Circuit was considering the merits. And the Supreme Court then set that issue for oral argument. That, I cannot think of the last time that happened. That is very unusual. And I think it was meant to send a message to the lower courts, which I think many of them will hear loud and clear. And one of the major messages that it sent is about how you think about staying, whether you should stay an agency decision. Traditionally, when you want to get an injunction from a court of any kind, you need to show that you will be suffering irreparable harm, that you have a likelihood of succeeding on the merits, that there will be no grievous harm to the other side, and that the balance of public interest weighs out in the right way. The irreparable harm presented that in the court's opinion is that the states will face competition from other states and that there will be compliance costs. These things are true in almost every policy decision. And traditionally in most of the lower courts, that would not be enough. You would have to show some extra level of, compliance costs that are pushing me to the brink, something like that. There's none of that here. The Supreme Court says, those are really important concerns, so we just need to think about the likelihood of success. That's a very strong message, I think. Ben, would you agree with that?
I don't know about you, Keith, but I don't think that I have ever sought a stay in the United States Court of Appeals for the Sixth Circuit, where the court then set oral argument, took briefs, took it under submission, and then issued the decision. So I agree that this is telling the intermediate appellate courts, at least, that it's encouraging them, I think, to issue stays in contested matters. I think back a little bit to the rash of stay applications to COVID regulations. And so, something like that were to happen again, I think that a court that is looking to the Supreme Court's example is going to be much more open, I think, to issuing those stays than perhaps they were a few years ago.
Yeah, I think that's right. And there is a second aspect to this that is maybe a little bit too deep in the weeds for this forum, but the way that the court thinks about what is arbitrary and capricious and its willingness to issue a stay purely on the, like, there's no question here in this case. The court is not saying that EPA is not authorized to do what they did. Not saying it's unlawful. They are saying that the rationale, the explanation of it is arbitrary and capricious. And on that basis, that's enough to stay. That is also fairly unusual. And I think overall, this case is going to make it much more common for agency rulemaking and agency decisions to get stopped at the courthouse door rather than only after, 15 months of briefing. So, okay, so that's Ohio versus EPA. Then when you get into it, Loper Bright is going to change how the court decides questions of law. So we should talk about what Chevron meant. Chevron was a doctrine that said, and this is, I should be clear, I'm not talking about the original Chevron decision from 1984, but what it became, what it eventually meant in the federal courts, was that when an agency has issued an interpretation of its statute and done that in a sufficiently formal way, that the court is bound to accept that interpretation as long as it is within the bounds of what's permissible, even if the court disagrees that it is actually the best interpretation of the statute. If the language is ambiguous, there's some scope of what is permissible for the ambiguous language. The agency can't decide that black is white, but there's some within those bounds. The court is not going to decide what is the best interpretation. It's going to accept whatever is the agency's view. That is the specific thing that Loper Bright overrules. And the consequence is that now, when you come to a court and you want to fight about the statutory interpretation, the agency can no longer wave the Chevron flag as they did right and left. I've seen this in almost every government brief, including circumstances where it was patently inappropriate. That will no longer happen. The court in principle is supposed to make its own judgment about the interpretation. And one of the big consequences of Chevron was that because the agency is allowed to make its policy choice, that can change. That can change from one administration to another. It can change in response to a court decision. There was a famous decision written by Chief Justice Roberts about 13 years ago, in which the IRS got a decision they didn't like from the Eighth Circuit, and then they wrote a rulemaking saying, well, we disagree, and here's what we still think the right answer is on the statute. And the Supreme Court ended up saying, well, the IRS wins that because of Chevron deference. So that's changed, obviously. So that is going to make in principle, a lot of difference when you come to court to fight about some agency policymaking. That said, none of this is absolute. There were many kinds of deference before Chevron, and many of these will survive. The Supreme Court in Loper Bright, it acknowledged some of these pre-Chevron doctrines, and it said, well, yeah, these might still be in place. What has died is the across-the-board presumption that nearly every agency gets this for all of their statutes. So here's just a few examples. This is not meant to be an exhaustive list of the pre-Chevron doctrines about deferring to agency interpretations. Skidmore is something that many of you may have heard of. This is about an agency interpretation that has the power to persuade because of, it's been consistent, it derived from soon after the statute was enacted, etc. There's a case called Red Lion versus the FCC, which held that the court should not overturn the agency's interpretation unless it was clearly wrong. Curtis Wright, a Supreme Court case from the 50s or 60s, saying that the executive branch gets deference for interpretations in matters of military and foreign policy. There are also statute-specific forms of deference. We've put one here, which is Ford Motor Credit. This is the Federal Reserve getting deference for the Truth in Lending Act. There are many others of these that the Supreme Court cited some examples in the Loper Bright opinion. National Muffler was deference on tax matters from a few years before Chevron. And the Securities Industry Association is banking agencies for the banking laws as just an example of one of the many ways in which agencies might get specific forms of deference in specific areas. Medicare is another example of this you can imagine. The bottom line is that although we no longer have the absolute Chevron deference of you must follow the agency within the bounds of reason, no matter the agency, there are many ways in which courts will still defer to agencies on statutory interpretations, and it will just be much more nuanced now, going back to that big point from the beginning, more nuanced about which agency, which statute, which case you're dealing with. As a practical matter, in a lot of circumstances, the Loper Bright change may not make much difference. If the court is going to go with the government, it may not matter to you much whether that was whether the government won because of a Chevron doctrine of absolute obligation or because of a Skidmore or Red Lion deference because I respect what the government has to say. I read one piece recently that observed that the absence of Chevron does not mean that the government's opinions carry no more weight than mine. The government still gets a thumb on the scale, and it may not, in many circumstances, it may not matter too much as a practical matter whether that thumb is made of concrete or of lead. Hattie, what do you think this means to people in the agencies, though? If you're writing policy, if you're writing a rule, you're making decisions, and you no longer have Chevron, what do you think that means as a practical matter for how they do their business?
Couple of things. First of all, I want to say that right now, agencies, I think they're just like us. They're like, what does Loper say and what does it mean, right? They're struggling with this as much as we are. Like I saw something the other day, just acting Secretary of Labor, Julie Sue, said she's not worried about Loper. She's going to continue to stay the course. And she said this, I think virtually this is the exact same day as a court in Texas has already blocked their DOL's expansive overtime rule citing Loper, right? So there's clearly a disconnect there. I mean, no agency is going to publicly say that they've lost their authority to act in certain ways. But I do think in some areas where they're looking to break new ground or take a policy position that's dramatically different than the predecessor did, that they're going to dot their I's and cross their T's in new ways. But they're still sorting it out, I think, like the rest of us are.
That makes a lot of sense. I will say from my own experience in government, I've always thought of Chevron as being two kinds of doctrine. One is a protection for an agency that really wants to push the boundaries. We want to change the way this statute is thought of in this area by adopting some interpretation that we're going to say, the statute was ambiguous, and what happened in Loper Bright is probably an example of this, where the agency pushing these costs onto the fishing vessels, they probably understood that was going to be quite contentious. Mm-hmm. I have to say that in recent years, this version of Chevron has been somewhat weakened in the Supreme Court already by means of things like the major questions doctrine that has evolved over the last 5 years. Mm-hmm. The other piece of Chevron is a rule that says, so if you're at an agency and you're trying to write some rule or decision that turns on agency interpretation, it is a lot of work. I can tell you, as somebody who does statutory interpretation, it is a lot of work to kind of try to figure out what is the best meaning of an ambiguous statute and what's my forecast about what a court is going to do. And so the agencies, they're doing this work. They're resource constrained and trying to write these 1,000-page rulemaking documents, and they make these judgments. And Chevron was a doctrine that says if they come close enough, good enough. This is the deference to something that's within the realm of reason, even if it may not be the best. That's sort of a play in the joints doctrine, a certain amount of slop. That I think will make a great deal of difference because it's unclear how the existing forms of deference will play out and the degree of error that courts will accept in statutory interpretations. And I don't know about you, Patty, but I feel like it's a message to agencies that they need to do a lot more work as they think about statutory interpretation.
No, agreed. I mean, thinking back in my days at, the Department of Transportation, where you're not making decisions saying, oh, close enough, I got Chevron, on my back. The concern is mostly if you're doing a high profile rule, you are certain to be sued on this. And quite often people were agency challenges, we're succeeding under Chevron, right? Because there's folks out there with very, very keen interest. Back in my agency regulator days, it was less a fear that, or less confidence that Chevron would protect me and more that all the folks out there fighting me on this rule would be successful in a lawsuit. That's what I was trying to bulletproof my rule against. I don't remember ever saying Chevron's got my back.
Just to jump in for a quick second, so that this is all correct, but it is also true that that Loper and the demise of Chevron does give more license to courts, more power to courts to decide the case the way they want. And it does certainly, if you are litigating in court, enables certain arguments that you could not have made before. So, for example, for me in the enforcement context, I think one place where this hits is in the sanctions context. So a lot of times OFAC's determinations on sanctions did win because the court just cited to Chevron. And so I think that's the fact that they can't do that anymore is going to enable a lot more arguments. Now, whether those arguments are ultimately going to be persuasive may or may not be the case because of exactly what Keith said about the government still having its thumb on the scale in interpretive decisions. But there's no doubt in my mind that there are new arguments that can be made and that there is more power located in the court than there was before.
I think that's absolutely right. And one of the arguments that is enabled now that was previously unavailable has to do with change. Under Chevron, it was very clear that if the statute is ambiguous, the agency can pick interpretation 1 today and interpretation 2 tomorrow. That happened in Chevron itself, actually. Chevron, the actual case from 1984, involved EPA's changing its mind about what is the definition of a stationary source for a particular provision in the Clean Air Act. And it used to be that they thought it was separate things were each stationary, and now they put them inside a bubble. There's a famous example of this that is still litigated with respect to the FCC about the regulatory status of broadband internet services. That has changed at least 3 times over the last 20 years, roughly, and probably more than that. I think it changes, roughly speaking, every administration. The FCC goes one way or the other, and this has to do with net neutrality, which is the consequence of the FCC's regulatory classification of these services. That kind of back and forth will no longer fly because all of the deference modes that I described, none of them accepts the notion that the interpretation changes over time. That is a very Chevron thing. In the absence of Chevron, the government comes in today and they tell me the interpretation is X, and the court might well defer to that. But if it's different tomorrow, that's, I'm as a litigant, I'm going to say that, I'm going to call foul. It has to stay the same. So the next thing we should talk about is what happens if you've got some past decision. It's worth emphasizing again here what happened in Loper Bright. There's a rule from the Federal Reserve from 13 years ago that is now being freshly litigated in the District of North Dakota. I said earlier that I was going to talk about the difference, what it means to say that they could bring a facial challenge. For statutes that have the background statute of limitations, which is 6 years, it was generally understood that you can still, after the 6 years, you can still contest the particular application of a statute. This would come up in enforcement, for example, where you might say, the application of a regulation. You might say in an enforcement matter, that regulation, your application to me in this enforcement situation is not something the statute allows. But when you do that, you don't get to say that the regulation as a whole is arbitrary and capricious. You don't get to challenge whether it had the right notice and comment, whether the cost-benefit analysis was adequate, all of these things. Those are all components of a facial challenge, the kind of thing that happens at the outset, meaning, within that 6-year window. What the Supreme Court is now saying is that Corner Post gets to do a facial challenge because they are within 6 years of their opening their doors and first paying these fees. They get to contest whether the 2011 rule was arbitrary and capricious, whether the 2011 rule had adequate notice and comment, and all the rest of it. Everything that one could have done in the challenge at the outset. That, I think, is going to open up potentially many cans of worms. We've got, for one thing, there are lots of old rules that one might or might not like. It's not just rules. It's agency actions that are subject to the background statute of limitations. And the criterion is simply that I was freshly injured, or that my injury, maybe if I had a prior injury, a fresh injury is not enough, but that I have somebody who was not injured and has a new injury from the agency action. It seems to me this is not hard to come by. Corner Post is a new entity that was formed in 2017 and opened its doors in 2018. If I would like to have somebody who is freshly injured by some agency action, there could be a new company. There are always new people coming into their professions over time. So new injuries, there will always be new injuries. So I think there is the potential here for many actions to be evergreen, as it were, with respect to the potential challenge. Not all of them. And we should mention that the background statute of limitations, that applies for statutes that don't have special review provisions. There are many statutes that have much tighter timelines, and those timelines are, for the most part, explicitly triggered by the agency action. We've listed some examples here of both kinds. So, for example, the Federal Communications Act, you have to sue within 60 days. Depends on 30 or 60, depends on what kind of action, but 30 or 60 days of the action. Similarly, the OSHA, the Clean Air Act, and many others. Again, not an exhaustive list, but these are many of them. There are, however, many very important statutes for which that is not the case, for which we're dealing with the background 6-year statute of limitations. Clean Water Act, for example, the Commodities Exchange Act. So if you are thinking about fighting a CFTC rule, Federal Trade Commission, the one that's very prominent in my mind is FDA drug approvals, would be subject to the corner post doctrine. So there's a whole lot, and I can tell you that I certainly have clients who are asking questions about past decisions that they have relied on, because it cuts both ways. There might be some rule that you don't like and it's old, and now you have the opportunity to challenge it and you would like to do that. There might be some rule that somebody else that you are perfectly happy with that somebody else might want to challenge, or some past decision like a license that you are enjoying that somebody might freshly want to challenge. So there's a lot of room for potential mischief. Patty, we talked, for example, about cafe rules. I mean, I guess maybe these 12 years old cafe rules don't matter anymore, I suppose. But NHTSA is an example of, and the EPA actions under those are an example of corner post vulnerabilities, I think.
No, agreed. And I'm thinking, it's so hard to predict where this is. I don't want to sound like I'm dissenting in corner post here, but this could just be potentially just massively expansive litigation. And I'm thinking we'll see how it comes out of the gates, but I'm certain Congress is watching as well. And Congress could say, listen, enough. I'm going to impose a firm statute of limitations. I'm going to, reverse corner post or something like that. But, if you want to challenge something, go for it now, because I'm just not certain, depending on the extent of litigation, the volume of litigation, I'm not sure this will remain an option.
Yeah.
Indefinitely.
So, it may or may not. We'll have to see. And I should mention also, Loper Bright, there's a paragraph towards the end of the court's opinion that says, we're not upsetting past decisions because any prior decisions that relied on Chevron are still binding precedent to the extent that, because that was just an interpretive doctrine. I would take very little comfort from that. I'll give you two reasons. One, Corner Post illustrates one of them, which is that Fed rule was litigated in the DC Circuit, and Corner Post is going to litigate in the District of North Dakota, where it's going to get appealed up to the 8th Circuit, where the DC Circuit's opinion is not binding precedent anyway. So knowing that the DC Circuit's precedent would continue to bind the DC Circuit will not help the Fed at all. Second thing is, I will tell you, one of the, if I look at that paragraph in Loper Bright, one of the decisions that stands out most as what the Supreme Court was talking about was their famous Brand X decision from about 15 years ago, maybe 18, about net neutrality. I will tell you, the FCC just filed a brief in the 6th Circuit in which they said that aspect of Brand X was not actually binding precedent anyway. So the government itself recognizes that there are risks and opportunities and nuance in these things. And so that paragraph in Loper, so past interpretations relying on Chevron are fair game, just like the rest of it. So the next thing we should talk about is, Jarkesy? Did I get that right?
You nailed that, Keith.
So let's talk about Jarkesy and what that means for enforcement matters. We just talked about affirmative disputes against the government. Now you're facing some enforcement. I will tell you what looked like before Jarkesy is came from a case called Atlas Roofing, in which the Supreme Court had said, generally speaking, when the government is pursuing enforcement action against you for civil enforcement, penalties, etc., that can be done in administrative adjudication under what's called the public rights doctrine. Doesn't need a jury, doesn't need a court. It gets appealed to a court, but the initial, the fact finding and the decision can be done by an administrative agency. And so that has been replicated in many, many areas in the federal government, far beyond the SEC. And what do you think, Ben? Is that all now in flux?
In flux is the right way to put it, Keith. I wouldn't necessarily say that it's gone by the wayside. I think it's way too early to say that. But I think that in my mind, there is a huge amount of uncertainty. Obviously, if push comes to shove and you're an entity that is going to tangle with a federal enforcement agency, there's a big difference between doing it within the agency and doing it in federal court. To state the obvious, in federal court with a jury, you've got the federal rules of civil procedure that apply, and that includes such important things as discovery, which are not necessarily things that one has at one's disposal in federal administrative proceedings, which are not uniform across the board, and there's a lot of variation. But I definitely think that influx is a good way to put it, because if you look at the decision in Jarkesy, it's one of these cases where the opinion is very clear that if the SEC is seeking civil monetary penalties for anti-fraud provisions, okay, that has got to go to federal court and a jury if the defendant wants that. But how that translates to even within the SEC, if the SEC is seeking some other kinds of remedies, for example, disgorgement, or if the SEC is pursuing enforcement not pursuant to the anti-fraud provisions of the securities laws, or if another agency is proceeding under a completely different statutory scheme, maybe an anti-fraud kind of provision, maybe not. All of that, to my mind, is quite unclear in the wake of Jarkesy. And so I think uncertainty is the main takeaway. But I would say, if you are an entity that is on the receiving end of an investigation by a federal enforcement agency, it's not going to feel like you've got there's no doubt that agencies in the balance of power has shifted in light of Jarkesy, but it's not going to feel that way if you're on the receiving end of agency enforcement. Because what Jarkesy does not change is it doesn't change anything about the agency's powers to investigate. So you're still going, if you receive a CID or the like, you're still going to have to deal with that. And what I think it does is it presents opportunities in the course of responding to an investigation, if you are in that space, that there's going to be different considerations and a different calculus by the agency as far as how far and how hard do they want to push on particular enforcement actions, because their risks of doing so, I think, have gone up in light of this decision.
I think they have, and I would say the two things that strike me as changes. One of them is very explicit, and the other one's a little bit of a sleeper. This court does love to put little sleeper lines in. The one that was very open was saying that the concept of public interest doesn't mean what we thought it did. Recall I mentioned that Atlas Roofing from the 70s had said when the government is doing enforcement, that doesn't have to go to a federal court because that is something called public rights. And the Jarkesy, the court says public rights is an exception, and it is very narrow. It does not mean this broad thing that you all thought it meant. It is very narrow, and it is about specific things. We don't know the exact scope of it, but it is not, we can no longer make this sweeping statement. It seems to me now that in every enforcement matter, I have to ask, is this one actually public rights? Which is a question that nobody had to ask for the last 40 years.
Well, I agree that you've got to ask that, but I think that from my perspective is that it's a question that's going to be asked on all sides of the matter.
Yes.
So, right. So if push comes to shove, the question is I would think for the agency, how worried are they that they might end up with a bad precedent on this issue?
Right. I think that's right. And the other, the sleeper line, it used to be generally thought that even when there is a need for when the Constitution says that you get a federal court, it would be acceptable for the agency to do the fact finding, and then you have sort of like your review of that in a federal court. And Jarkesy says, in passing, that when you've got something that is supposed to go to a court, the court has to be doing the initial adjudication. So it seems to me, and again, this is going to be litigated over the next 5-10 years on an agency by agency basis, as people are going to say, no, this one. Just for the audience's awareness, all of us who litigate against the federal government, everybody, July 1st and 2nd, we were filing notices with courts around the country saying, hey, you just inform you this decision came out. Here's how it affects my pending case. The first one that I filed was not about Loper Bright. It was about Jarkesy. So let's talk briefly, if we could, about Patty, about what do you think is going to be the reaction within the federal government, at the agencies at Congress?
Okay, good. Yeah, let me move quickly through this. First, a couple of things. How will agencies respond and how will Congress respond? First of all, a couple of base rules. I'm assuming, because there's just too many variables, we're talking about our current scenario where we have a Republican House, a Democratic Senate, and a Democratic White House. And particularly the House Republicans are strong supporters of Loper Bright. I don't want to burst anyone's bubbles here, particularly not the House Republicans, but I don't view Loper Bright as inherently the deregulatory statute that just crumbles the administrative state that some of these folks are saying, right? I mean, maybe under the current fact scenario, as I mentioned before, that the immediate impacts of Loper Bright will be to kind of rein in some of Biden administration regulations. But if a Republican takes the White House in November, or actually, wins in November, takes it in January, Loper could actually impede that Republican president's efforts to deregulate or to roll back some of the Biden administration regulations. So in that way, something Keith and I have talked about already, I think Loper could in some small way provide greater regulatory consistency across presidential administrations. This is something Keith mentioned, like cafe standards is an example here, where the Biden administration set strict cafe standards. Trump administration pulled those standards. Or no, Obama strict, Trump pulled, Biden now puts in stricter ones, right? That type of, whipsawing back and forth. I see Loper putting the brakes on that. But generally within the agencies, I think that, mentioned this briefly, I think agencies have already been working very hard to justify their decisions in the rulemaking process well before they come to a legal challenge. As I mentioned before, interest groups across the political spectrum have routinely successfully challenged agency rulemakings, even under Chevron. And also, the Biden administration has been working hard to protect some of its most controversial regulations, most high-profile regulations, not from challenge under, Chevron or Loper. I mean, I'm sure they saw Loper coming like us did, but basically challenges under the Congressional Review Act, which should Trump win in November, right? So this means that most of the big controversial rules that Biden wanted to accomplish have already been issued in an effort to keep them outside of CRA review. So I'm not sure how many, if in the Biden administration, how many major rules will be even up for consideration now post Loper. And then also, but agencies are going to have internal discussions on the best way forward on this. We certainly expect them to maybe proceed on policy changes more incrementally than they had before. And maybe they would opt for informal guidance or interpretations to encourage maybe what they think they can no longer require. And I'm pretty confident that they're going to dedicate more resources to this. Keith mentioned earlier that rulemaking process is very time consuming and it's very resource intensive. So they'll have more statisticians, more engineers, more lawyers, more data to back everything that they do. But in some cases, again, we talked at the very beginning, Loper doesn't throw at everything. It doesn't change everything. The ordinary churn of the administrative state is going to continue. So much regulatory action. It's too technical for Congress to legislate, and it's just too much in the weeds for judges to intervene, right? If we think about some things, really straightforward rules, you're doing what Congress directly told you to do a rule on X. I think those things are, will not be challenged under Loper because they wouldn't be protected under Chevron. They're outside of the scope of that, right? Food safety inspection laws that have been on the books since, for the past 100 years, seatbelt laws and vehicles, these federal laws, those I think are safe and outside of the review, right? And Congress, I think, lacks the expertise and resources to do a lot of specificity on some of these rules, so they're not going to step in. But of course, again, caution on the most controversial issues where the politics seem to sway this. And then just one point to make, that because I've heard it come up in other contexts, some things that are simply absolutely not on the table after Loper are Supreme Court decisions on constitutional rights. Just keep in mind, same-sex marriage, that's not a question of interpretation, agency interpretation of a rule. That's a constitutional right. The abortion decision, again, these things are off the table. That's not at issue. So again, to kind of define the scope of what we're looking at. And then basically now I want to pivot to how I think Congress is going to react. And again, it depends if you're a Republican or a Democrat in some ways. But I think that, Oversight Committee Chairman James Comer said recently that Chevron was showed the agencies were able to usurp congressional power. I don't think that's the case. I think that basically Congress ceded their authority through, polarized paralysis and slim majorities and divided government. So it's left the agencies to fill in the gap. And when I was a Hill staffer, I helped perpetuate this situation, right, of government expanding regulations. I created a new regulatory agency when I was there, right? So these agencies don't grow organically. They grow because Congress created new agencies, Congress gave new power, Congress funds them every year. So, Congress is part of the problem as well. I don't see Congress, real briefly, just finish up here, I don't see them filling in the gaps to the extent they maybe would be permitted to, for the same reasons why they haven't passed, very specific laws since the 70s, right? They're limited staff, limited ability to regulate. They're trying to accomplish the basics. There are 12 spending bills each year, the defense authorization bill. Those are the basics, and they're trying to get the farm bill done. Beyond that, I don't see a lot happening. And also, Congress already has tools that they absolutely love to use. They love to use the Congressional Review Act, even if they can't successfully use it, for example, in this administration, because Biden's not going to sign into law any bill that pulls his regulations. But they love oversight hearings, they love Congressional Review Act, they love appropriations funding bans, and nominations. For example, this is why the Department of Labor Secretary, she's just an acting secretary, because she cannot get the votes in the Senate to get confirmed. So those are tools that Congress will continue to use. Back to you, Keith.
So as we're nearly at time, I do want to take anybody's questions if you have any. So go ahead and type them. And I do see a question about whether we're going to send the recording out. Yes, we will be sending the recording out. If you have any questions, go ahead and put them in that Q&A box. And while people are doing that, let's just do around, what do you think a regulated entity should do in this new environment? Ben, let me start with you.
I think a regulated entity needs to absolutely stay on its toes. A regulated entity needs to have all of its feelers out and ears to the ground and be fully engaged, because there is so much more uncertainty than there was last year.
Excellent. Patty?
I would say stay engaged as you were, if not more so, at the rulemaking process. The fact that you could have, the balance is tipped in your favor in litigation doesn't mean you should let down at your chance to implement and affect rules early on.
Excellent. And for myself, I would say you need to be nimble, even more so than you used to be, and especially in compliance. The additional uncertainty, both temporal, things might fluctuate more over time, Corner Post is going to might upend an old rule, and the nuance of things being more different from agency to agency means that in your advising and in your compliance work, as Ben said, you need to keep your ear to the ground, and you also need to be even nimbler than you were to be able to respond. Thank you both for helping me talk to everybody about this. This is important and exciting and terrifying all at the same time. Thank you, everybody, for attending. And if you do have any follow-up questions, you will have all of the email addresses for all three of us. Please feel free to reach out. As you can tell, we love talking about this stuff. Talk about it all day. Thank you, everybody.